eligible to get a marriage-based green card if you are a DACA recipient living in the United States. I'm immigration attorney Kalani Hawks Villafranca, and I have helped many clients who are DACA recipients who are married to U.S. citizens or residents to get their own green card and legal status in the United States. So here we are today talking about what those options look like for you if you're a DACA recipient married to someone who has a legal status here in the U.S. So first of all, I want to say that if you are a DACA recipient and you are married to either a U.S. citizen or a lawful permanent resident, that you absolutely should talk to an attorney about what it would take for you to get your green card, because you very well may be eligible. So first things first, you have to either be married to a U.S. citizen or a lawful permanent resident. If your partner, your spouse, has a status other than those, like say they have a student visa or they also have DACA, that won't support your marriage visa. For a marriage visa, your spouse has to be either a green card holder, which is also known as a lawful permanent resident, or a U.S. citizen. And they can get their citizenship either at the time of their birth or later. If they became a citizen later in their life, not at the time they were born, that's fine too. It doesn't impact their ability to get your status. So if your spouse is a citizen or resident, you can become a green card holder if you're eligible. So that's step one, is make sure that your spouse has the proper status. Step two is make sure that you yourself are actually eligible for a green card. Anytime that we file a marriage-based green card case, we have to prove two things. The first is that you're actually married to somebody who can support your green card. The second is that you, the person asking for the green card, are actually eligible. In this video, we're not going to go into every kind of eligibility because there are a lot of ways that may impact your ability to get your green card. And so I really encourage you to have a consultation with a trusted immigration attorney. But today we're going to talk about some of the big ones. So if you have had any contact with law enforcement in the past, that may impact your ability to get a green card. If you have had any deportations in the past, or you've had any contact with immigration authorities, that might impact your ability to get your green card, even if you're married to a citizen or resident. So those are two of the most important and major issues that I see a lot of times with clients. So if that is true for you, you absolutely need to consult with an attorney and figure out what your eligibility might be. A lot of times we can get waivers for these things, or we can help you figure out another option to get your status. But let's assume for now, you're married to a U.S. citizen or resident, and you don't have any issues in your history that would make you ineligible for a green card in the United States. So what next? If you're a DACA recipient living in the United States and married to a citizen or resident, there are two ways for you to get your green card. The first path is staying here inside the United States and applying from within the United States. The second path is starting the process here and then finishing the process by going abroad to your home country. For many of you, that's Mexico, and so you'll go to Ciudad Juarez and finishing your green card application in your home country. Now, if you're like many of my clients, you want to know, how can I stay here and do the process here? Well, you don't always get to pick. So we're going to talk through what the options are and which options are available to you depending on your background. So to apply for your marriage visa, to apply for your marriage green card, as a DACA recipient living in the United States, and to do so without leaving the United States, you have to be married to a U.S. citizen and have entered the country with permission the last time you came in. So let's talk about that first point. You have to be married to a U.S. citizen in order to adjust your status, which is the legal name that we give to getting your green card without leaving the country. So if you want to be able to get your green card without leaving the country through your marriage, you have to be married to a U.S. citizen. Marriages to lawful residents are not eligible for this. You'll have to go abroad to get your status if your spouse is a resident, unless you've always maintained your legal status. But that is going to be problematic sometimes if you are a DACA recipient. So generally, you need to be married to a U.S. citizen. You also need to have entered the country lawfully the last time you came in. So for a lot of my DACA recipient clients, that looks like having entered with a visitor visa when they were 4 and overstaying that visa and they're now 37. So if that's you, that counts. Even if you've been in the country a really long time without permission, if you last entered lawfully and you're married to a U.S. citizen, you can stay in the country and adjust your status here. Now, what if you're not? So if you are either not married to a U.S. citizen, So your marriage is to a resident. Even if you last entered lawfully, you're going to have to leave the country unless you've always maintained your lawful status since you got here, but that is not necessarily going to be true for you if you're a DACA recipient. There are some limited instances where it might be true, and so check with an attorney always before filing your case. But if you last entered the country without permission, regardless of who you're married to, you're going to have to leave the country to adjust your status and get your green card. So if you're married to a U.S. citizen, even though you're married to a U.S. citizen, the last time you entered was without permission. Maybe you came in on fake documents or you crossed the river without permission. You're probably going to have to leave and go process in Juarez. Now, attorneys have a lot of tricks and tips and things we can do. So if you entered with fake documents, sometimes we can claim that you entered with inspection, which means that you presented yourself at the border and you were let in, even if you weren't let in with the proper documents. Sometimes that is enough to allow you to stay in the country and adjust your status here, unless you claim to be a U.S. citizen. Because claiming to be a U.S. citizen is kind of the worst thing you can do for immigration purposes. So if you've done that, it's really hard to overcome. But to review, if you're a DACA recipient, you can adjust your status here in the United States without leaving and get your green card here in the United States without leaving if you're married to a U.S. citizen and you last entered the country lawfully. There are some other limited instances where you may be able to stay here and adjust your status, but they are significantly less common. If you're a DACA recipient and you're married to a resident, or you're married to a citizen and you last entered without permission, then you're going to have to leave the country and go to Ciudad Juarez to process your green card, or to your home country. Most of my clients need to go to Ciudad Juarez because most of my clients are from Mexico. But you'll have to go to your home country to process your green card. So what does the process look like? Now we know who gets to stay here and who has to go abroad to process. What does it look like in each instance? So for DACA recipients married to U.S. citizens who are going to process their green card here in the United States, we do what's called a one-step process. That means we can combine the whole green card application and file it all at one time. Anytime we file an application for a family member to get immigration status, the first thing we do is prove the family relationship. The second thing we do is prove that the immigrant is eligible for the status they're asking for. If you're married to a U.S. citizen and you're going to apply in the U.S., we put those things together and we send in the whole packet all at once. It's called a one-step adjustment of status application. After we file your case, it usually takes about 6 months for you to get your work permit and travel permit that will be yours while your case is pending. It's not your permanent work permit. It's not a green card. It's just your status while your case is pending. These cases tend to last anywhere from about 8 months to 2 years. Timelines are all over the place right now. But after you get your temporary work permit and travel permit, that's your ticket to continue to stay in the US and work. And it also gives you permission to travel abroad, though don't do that without talking to your attorney to see if there are risks for your case to leaving the country. And then eventually you'll get notified that you're ready for an interview. You'll go to your local immigration office for your interview. They'll ask you about your marriage. They'll ask you about your life, any concerning issues with criminal history or deportations. They'll ask you about all that kind of stuff. And then hopefully at the end of that, they'll let you know you've been approved and you'll get your green card. And that whole process takes place within the United States. While your case is pending, you can continue to renew your DACA status, and we absolutely encourage you to do so. I don't ever want you to be without an immigration status and the ability to work. So you should absolutely continue to renew your DACA status while your marriage case is pending. It is not common for people to get denied. If they've worked with an attorney, they've filed a clear case, but denials do happen. And I don't want you to end up in a situation where your case is denied and you chose not to renew your DACA status and now you have no immigration status and you're at risk of deportation. Don't do that. Don't let it happen to you. So even if you can process your whole case here, keep your DACA status current while your case is pending. Do not let your DACA status run out until you actually are a resident with a green card. All right, so that's how we change your status within the United States and get you a green card without having to leave. What if you have to leave the country? What if you're one of those people who, like many of my clients, didn't enter with permission, and so they cannot stay here to get their green card, they have to leave? Many DACA recipients entered the country with their parents without lawful permission to enter. Because of that, they're not able to stay here to get their green card if they're married to a U.S. citizen or resident now. You can start the process here. So step one is that we'll file your paperwork while you're still in the U.S. with your DACA status to prove your marriage relationship. That will all be decided in the mail, in paper. There will not be an interview for that process, probably. They'll just let you know it's been approved. Once that's been approved, then we move to step 2 and step 3. Some people are going to need step 2 and some people are not. So step 2 is getting a waiver of your unlawful presence in the United States before you leave the country. If you have been in the United States for more than a year without permission, then at the moment you leave the country, you're going to get something called the 10-year penalty, and it's going to prevent you from coming back in the country for 10 years, and you do not want that. So to avoid that, we can do something that's called a provisional waiver process, where we ask for forgiveness of that unlawful presence, and we get an approval and say, yes, you've been forgiven before you leave the country, so you know the outcome of that waiver application. A really important note for DACA recipients is that if you have always had DACA since the age of 18, and you have not had a period of time of a year in there without status, you're not going to get that 10-year bar. There's also a 3-year bar that you get if you have had a lack of status for 6 months. So we want to know for DACA recipients, if you've always had DACA since you've turned 18, then you don't have to worry about this provisional waiver process because you have not triggered that 10-year bar because you've maintained status since you've been an adult. So it's really important. Many of my DACA recipients can take advantage of that. So while they still have to leave the country, leaving the country feels less risky because they haven't triggered this 10-year bar process. If you have, then we'll need to make sure that we can apply for a provisional waiver for you before you leave the United States. To apply for this provisional waiver of your unlawful presence, we have to either show that you have citizen or resident spouse or parents who are going to be negatively impacted if you have to stay outside the country. So it's a pretty high bar, and it's a lot of work to put these applications together. So if that's you, I need you to be really clear that these applications are time consuming and can be kind of hard on the family involved. So I want you to be thoughtful and take your time to put together an application properly and get your attorney all the information they ask for, because it's really important to have all the evidence you need for this waiver application. You want it approved and you want it really clear before you leave the country. Okay, so you've applied for step 1. Within the US, we've proven that your marriage is legitimate. Step 2, if you need it, we've applied for your provisional waiver and we've gotten approval of that waiver of unlawful presence. Step 3 is that we apply for an interview for you abroad in your home consulate, Ciudad Juarez or another country. In Mexico, you can only go to Ciudad Juarez. In other countries, there may be more than one location where you can process. And we get an interview notice. Once it's time for your interview, you'll leave the country and you'll do all the pre-interview things in Mexico that you need to do, like your medical exam or getting a police certificate, that sort of stuff if we haven't done that ahead of time. And then you'll go to your interview. At the interview, they'll ask you questions about your marriage, about your history. Your spouse will not be at that interview with you. They do not need to go. So only you need to leave the country to go to your green card interview in your home country. If everything goes well at that interview, you'll be notified that you've been approved, and they'll take some amount of time for your new documents to be processed. You'll wait for those to be processed. Could be a couple days, could be 2 or 3 weeks. You'll pick that up, and then you'll actually enter the country as a lawful permanent resident, which is super exciting. Shortly thereafter, you'll get your green card in the mail. So whichever path you choose, if you're a DACA recipient, whichever path is available to you because of your marriage to a U.S. citizen or lawful permanent resident, the good news is at the end of that process, whether it's within the United States or starting in the U.S. but ending in your home country, at the end of that process, you are a green card holder, a lawful permanent resident in the United States. And after another 3 years, you can apply for citizenship, which is hugely exciting because many of you have been living undocumented or in DACA status for decades, and being able to know that U.S. citizenship is within your reach is really exciting, and I want that for you. So if you have any questions about your case, give us a call, 512-675-2945. The number's here below. And I would love to do a consultation with you and figure out your particular case and your eligibility to adjust your status here or abroad. One other thing I want to note, DACA recipients are now eligible again for advanced parole. If you're a DACA recipient and you either have a sick relative abroad, your job needs to send you abroad, or you have an educational need abroad, you can get advanced parole, which is permission to leave the United States and re-enter after having gone abroad for that specific purpose. It is very important to note that advanced parole is considered a lawful entry. So if you're a DACA recipient who last entered the country without permission, and so you would only be able to get your green card if you went abroad to process your green card, you can change that if you're able to get advanced parole. If you get advanced parole, and you leave and come back in with that advanced parole, now you can adjust your status and get your green card without leaving the country. So that's huge. And it's a really important part of your case strategy. And I do this for my clients. And if I have clients who are married to US citizens and they are eligible for advanced parole, we do that for them. And we try and get them that advanced parole and change their eligibility from outside the US to inside the US for green card processing. Because anytime you can stay in the country, it's better. Because obviously, anytime you leave, there's a risk that you will not be let back in. And we don't want that for you. So keep in mind, if you're a DACA recipient married to a US citizen or resident, I want you to think about advanced parole and if that can be an important part of your case strategy. So talk to your attorney about that, or give us a call if you don't have an attorney and you'd like to chat about a consultation, and see what we can do for you and your family. It's been a pleasure talking to you guys as always. I'll see you next week. Bye.